Four of the men charged in connection with a house party shooting in Catawba County back in court today. The four accused are Mack, Izaiah Mitchell, Zachary Bates, and Toland Huff. They went before a judge to hear 10 additional counts of attempted first-degree murder. Judge also granted two of the four, Izaiah Mitchell and Toland Huff, no bond, while Mack and Zachary Bates received a $1 million bond with monitoring. So there are a lot of moving parts here in this case. Queen City News Chief Legal Analyst Khalif Rhodes here to break it all down for us. Khalif, a lot of people involved as this investigation moves along. Is this case going as expected as you would see right now?
It's moving through the process like it's supposed to. I'd say maybe not going as I expected in terms of what some of the reaction to the original individual being arrested, his bond being the amount that it was placed at $200,000, a number of folks being frustrated by that amount, him being someone that was already out on bond at the time and had been released from some type of charge previously. These amounts.
Discuss that process, though, because you're saying they had somebody in for the shooting suspect. Garen Killian is the alleged shooter. As the first suspect, but then he also came in, and we knew about this before he went into court on the next day after he was arrested, where he had 7 additional murder charges from 2 months prior.
Yeah, and those are the types of things when you have a person that's on pretrial release, it would confuse you with the size and the amount of bond that he received. Now I can say this, a couple things. The statute is 15A533, 15A534. Those are the two statutes that a judge will look at when making a determination for setting conditions for release. Now we hear of bond, that's one condition for release. You can have unsecured bond, you can have secured bond, written promise to appear or release to a third party. Typically that's like some type of pretrial services. In cases like this, where the bond is, or where the charges, are horrific like this, where you're talking about attempted murder, where you're talking about loss of life, any type of situations like that, a judge doesn't have to set bond if it's a murder case. If it's attempted murder, it says that they must set some type of bond. So when you're talking about what those conditions look like, you're looking at a couple of things: the nature of the charge, the weight of the evidence, their ties to the community, their likelihood of committing some new crime, specifically a new violent crime, and their ability to come to court. There's 11 factors that are listed in there, and the judge has to go through each one of those factors. So even setting that portion aside, typically you will also have something called their pretrial assessment, this risk assessment, that an individual, their likelihood of committing a crime based on their age. 25 years old is if you're below 25, you have a more likelihood of committing a crime. The older you are, the less likely you are of committing these types of crimes. So there's an algorithm, there's a system to it, and the judge is supposed to look at the factors that are given.
He should have known that before that suspect ever appeared in court.
They should, but I'm not saying that always happens, but they should. But taking everything into account, every case should be set based on the individual. So it shouldn't be, okay, you have this specific charge, this event that happened at this home. All of the individuals there shouldn't have the same bonds, because each and every one of them will bring something different, their own past to the table. So you have a couple folks that have no bonds. Maybe they had histories that indicated to the judge that this is a person that no condition that I set will ensure that they'll come to court and they won't commit some new crime. So I'm not going to set a bond on those individuals. But for these other folks, I believe $1 million bond is something that's sufficient to ensure that they'll come to court. But even that number, it's kind of a two-edged sword, because even though you are setting a condition, most folks don't have the resources to be able to come up with $100,000 to be able to pay that, plus to some type of collateral that they'll be able to have to come up with for a bail bondsman to get them out.
As far as that risk assessment, does that go into it? Says, oh, he might be able to make bail, so he gets out into the public, and then you have that outrage already from law enforcement, and also how incumbent is it on the DA, the district attorney, to make that known when they're in case. When that hearing happens for the
a couple of things
after for the bond hearing.
A couple of things. And so with the outrage portion, specifically from law enforcement, the statute and the standard requires, the judicial codes of conduct require that a judge set that aside, that they're not even, you should not be deterred in making a decision in worrying about how the public would respond. You're supposed to look at the four corners of the case in front of you and make a decision based on that. In terms of the individual's prior record, that should be disclosed to the judge, specifically a person that's on pretrial release. release because the DA should have stood up and said, hey, there's a rebuttable presumption. Within those two statutes that I mentioned, there's something called a rebuttable presumption that regardless of what you do, Your Honor, there's no amount of bond that could be set to ensure that the public is safe. So those are the normal things that are argued. Me as a defense attorney would be arguing back, hey, they make the rebuttable presumption argument. I'm saying we've overcome that rebuttable presumption argument. So there's this back and forth that's happening between both. And then the judge is in the middle playing the umpire, calling balls and strikes and making a determination and seeing which one they agree with. In this situation, I just think on that first case, the judge looked at something and said, I'll set $250,000. I can say that's not normal when you have a person that's out on pretrial. For the other ones, they seem to be typical for these types of cases, and it's going through the process.
No bond and $1 million bond.
That seems to be typical. I mean, for folks that I represent, I've had the whole gamut of a $250,000 to a no bond with the multi-million. I have folks now that are sitting there on $2.5 million. It really just depends on the facts. It depends on the judge because it's all their discretion, and it depends on what's being argued to the court.
And also, I want to make mention here, you do have a unique experience, not just being as a lawyer yourself. You've worked with the judicial system on these type of things as part of the bonds and being part of the magistrates.
As the former chief magistrate and here in Mecklenburg County, I helped to rewrite our bail policy. So the bail policy that is used, when I first got here, there was a number system. So there was a charge and it would say, hey, assault on a female, that's $25,000. Okay, you got charged with trafficking, that's $100,000. Well, that's not statutorily correct because it says that it should be an individual assessment of that individual person, not just what the bond says on the wall. So we did away with those and made sure that judges and magistrates were making a determination based on the individual. And when I was there, these types of cases a magistrate would have said. Now in our state, only a district court or superior court judge can set conditions for release for these type of charges, specifically gun-related, these violent type of charges. So yes, having an intimate understanding of how the process works, it definitely lets me know that that first one seemed to be outside of the norm, but these seem to be exactly how I would have anticipated they'd land.
All right, so we call them balls and strikes here and fair or foul. You're saying that the first one was a foul.
Should have been definitely a foul, but hey, they let that one slide right through and gave it a strike. But the rest of these folks,
but rectified because the bond has been revoked.
I can say that what happened is you had outrage, you had frustration, right? And because you have outrage and you have frustration, typically that's what will occur. But I can say that doesn't seem like what due process looks like either. If this individual hasn't done anything to be violated, it was out on bond, the judge has given the bond, they've come up with that amount and secured the amount to be released, at some point you're revoking them only because of the outrage, not because of the decision. And those are something that that's something that you don't want to have happen either.
Also discuss a little bit too here, because you've seen that as the case goes deeper and deeper, you've seen some of the people getting additional charges, and that's what's going to happen. You expect more of that too, as people are starting to understand and get this case kind of wrapped up as far as from their perspective for the investigation.
100%, I anticipate more charges because if you think about it, they talk to a number of folks. Most of these individuals are juveniles. You're talking to kids. Their stories will change. You'll do a number of follow-ups. You'll add those follow-up conversations to the physical data that you have. Then you'll add those physical data that you have to any type of warrants that you pull. So you get some cell phone towers. You're looking at any type of cameras that you can capture these folks that were leaving. So even if no one talked that was in that group, the data that's there can talk for itself, and it can speak and say, hey, you were in the car with them when they were leaving. You showed up to the party. Your phone pinged you right here at that time. Those are the types of things where you can kind of box someone in if they're saying, well, this is my story, this is where I'm at. Oftentimes have detectives will say, well, hey, if you're telling me you were at your parents' house, why's your phone pinging that you were over here across town? And then once they start to dump that information on the individual, more things start to come out through their own words. Their own words typically is what hurts them the most.
All right, Chief Legal Analyst Khalif Roj, thanks.
Queen City News Plus. Just search Queen City News on your smart TV's app store.